Hey, I'm Huck. And you know, I was wondering today, just kind of imagining, what it would be like to live in a country where, I don't know, say, teenagers had no right to free speech. Where, let's say, it was perfectly legal for prison guards to beat inmates senselessly inside their own jail cells. Where torturing terrorist suspects was considered appropriate. Or where it was perfectly legal for some school administrator to strip search a 13-year-old girl without parental permission in order to find out if she was hiding an aspirin or two. Fortunately, we here in the United States have a constitution that guarantees the right of free speech, that prohibits cruel and unusual punishment, and that bans illegal searches. Or do we? According to Supreme Court Justice Clarence, all of the things I just named are perfectly reasonable and justified under our Constitution. Another justice on the court, Antonin Scalia, sees nothing wrong with indefinitely detaining foreign combatants without right to see an attorney, without charges being brought, and held indefinitely, for years if necessary, and never bringing them to trial. Ever. Scalia also believes that states have the right to ban any form of gay sex, something that Thomas agrees with him on. In fact, Thomas's view on anti-sodomy laws goes one very big step further. His view of the Constitution suggests that if the police should break into your home in the middle of the night, even under false pretenses, and find you engaged in such an act with another consenting adult, well, the state should have the right to prosecute you to the fullest extent of the law. Due process be damned. These are just a few of the written opinions rendered by Justices Thomas and Scalia just in the last few years. Fortunately, they were each dissenting opinions, and the majority of the court ruled differently. But don't think for a minute that dissents don't matter. When a similar case comes to court, maybe a few years down the road, when one or two new justices have joined the court, well, the majority opinion and the dissents are the very first thing the justices will look at before making a ruling in the new case. One notorious example of this can be found when the McCain-Feingold campaign finance reform bill first passed Congress and came before the Supreme Court. McCain-Feingold limited the amounts of money that could be directly contributed to a political candidate. And it also provided limits and transparency to any donations indirectly to that campaign, including any issue-oriented soft money donations. A majority on the court upheld the McCain-Feingold law, but Justice Scalia wrote a scathing dissent. Years later, it was Scalia's dissent in the McCain-Feingold case that was used primarily to form the court's decision in the Citizens United case. The result is where we find ourselves now. Unlimited direct contributions to candidates and unlimited anonymous soft money support of candidates as well. Because of this change, today, for the first time really in history, it's possible for a single individual or corporation to fund an entire slate of statewide candidates for office, or to fund several U.S. Senate or congressional races single-handedly. One corporate-based donor, if rich enough, could outspend an entire field of presidential candidates. And we may never know, because they don't have to disclose, who it is that came up with all that money. It might even be a foreign business or foreign government. When you look at Scalia's reasoning, used in both of these cases, they have little to do with the Constitution, unless you equate money with speech and corporations as people. His argument goes something like this. Incumbents have an inherent advantage in collecting hard money direct contributions, putting challengers at a disadvantage. By limiting soft money contributions, he says, you are assuring that incumbents will have a funding advantage over their challengers. There are several problems with this reasoning, of course. One being that rights under the Constitution are intended to apply to people, not necessarily corporations. And while each of us as citizens have the right to free speech, that free speech does not equate to the money we possess. Because if that were true, if money were speech, then those with more money would in effect have the right to more speech than those with less. If all men are equal under the laws the Constitution clearly states, how can this be? How can the rich man be entitled to more free speech than the poor man? But there's another flaw as well. The truth is, incumbents enjoy many advantages over their challengers, not just financial. But it's not the court's job to seek to equalize that advantage. Because if it were, then they would have to address such things as government-paid mailings to each constituent, the amount of C-SPAN airtime incumbents get. But I digress. The point is, conservatives like Scalia and Thomas only pretend to follow the Constitution in reaching their political decisions. The reality is, time and time again, they stretch one right beyond all reason, say free speech, while completely ignoring other rights of the Constitution in the process. Throughout the history of the United States, there's been a sort of reverence, certainly respect, that's been afforded the Supreme Court, much more so than the other two branches of our government, probably because they are the final authority on legal matters in this country. And part of that deference to the Supreme Court stems from the fact that being the ultimate authority, the alternative to respecting their decisions could potentially lead to chaos, even anarchy. But the fact is, throughout our history, there have been those members of the court who have used the illusion of legal argument and constitutional theory to pursue an agenda. Sometimes, a majority of the court recognizes those members who are basically unfit to serve. Chief Justice Rehnquist, who retired during the Bush administration and one of the most conservative Chief Justices in our history, thought so poorly of the opinions written by Justice Clarence Thomas that he rarely assigned him the task of writing a majority opinion for the court unless it were a bankruptcy case. Conservatives would have you believe that everything in the Constitution is in black and white, either or, yes or no. But that's simply not the case. Our founding fathers left room in the Constitution to grant Congress extraordinary powers under extraordinary circumstances. One of the reasons for this is that Congress is the most accountable of all of the branches of government. They're elected every 2 years. They had a very difficult time convincing the individual states to ratify the Constitution. And they also realized it was equally difficult to have to ratify individual amendments to the Constitution in the future. Throughout most of American history, the Supreme Courts have consistently ruled that the Constitution actually allows some reasonable room for the legislature in particular to be able to react to different issues our founding fathers, frankly, could never have foreseen. And so a real problem arises when some members of the court use those gray areas, those clauses, to pursue a political agenda rather than to follow what the founding fathers had actually intended. The evidence increasingly leads many to believe that our current Supreme Court consists of several conservative members who are little more than political hacks, willing to ignore parts of the Constitution, even reinvent the English language itself in order to pursue an agenda. Justice Scalia, in the case District of Columbia versus Heller, a case that overturned D.C.'s gun restrictions, wrote for the majority, in his opinion, that the words well-regulated militia were completely meaningless and separate from the passage that says the people have the right to keep and bear arms. In their dissent, the 4 liberal judges of the court explained what any 6th grade student would know, diagramming any sentence, that the phrase, a well-regulated militia, was the purpose, the justification for the people to keep and bear arms. The dependency the founders wrote into the Constitution here is clearly the same as in the sentence, having graduated from a 4-year accredited institution and passed certification in the field, you have a right to teach school in Ohio. Using the very same interpretation, Scalia and the conservatives on the court would have to look at that sentence and say, you have an inalienable right to teach school. And all of that other stuff about accreditation and certification is, well, meaningless and separate. Scalia goes further in Heller to describe the words well-regulated militia as nothing more than an elementary level of discipline and training. This, despite all evidence to the contrary, including Article 29 of the Federalist Papers, written by both Alexander Hamilton and James Madison, which clearly describe what they mean by state-run militias and how they are used in defense of the country. Further, if we take the conservative arguments at face value, how then can we place any limits on gun ownership? Ban felons from owning them, for instance. If a state or a community cannot set reasonable limits, how then is it that you have to have a license to own a silencer? Why is it that you can't obtain a bazooka or a rocket grenade launcher? Apparently, not all restrictions are created equal. So where does that come from? Conservatives, backed by the National Rifle Association, claims it gives all individual Americans an absolute unfettered right to keep and bear arms. Yet conservatives labor to either ignore or completely misconstrue the words well-regulated militia in order to come to their Second Amendment reasoning. Put aside from the fact that our founding fathers probably never envisioned a day when 83 Americans would die by gunshot each day, or living in an age with flintlock rifles that took moments to load and shoot, how they could have never grasped the idea of an AK-47. The Heller decision, written by Scalia, makes reference as a surprising number of these Second Amendment-related case laws do to not just the Constitution itself, but its roots in Old English law, specifically the English Bill of Rights of 1689. The passage conservatives love to cite is one where gun rights are restored to Protestants, having had them revoked earlier by the Catholic King James II. But what conservatives never cite within that same English Bill of Rights is the passage that follows, which explains that restoration of gun rights to the Protestants. What they ignore is that they justify restoring those rights because King James II improperly removed those rights in the first place, having not gone through the Parliament in order to get their consent. That part about Parliament is rather inconvenient and not at all in keeping with the conservative agenda. An equally exasperating absence of constitutional reasoning can be found in another case. This one, written in a dissent by Justice Clarence Thomas. It involved a Texas case and an act of gay sex. A majority of the court looked at the case and ultimately threw out anti-sodomy laws not only in Texas, where the case originated, but in effect throughout the nation. But Thomas was not buying it. In his opinion, the state of Texas had every right to ban homosexual relationships. Thomas, that bastion of originalist thinking, wrote an opinion that is mind-boggling. The case involved a Texas man allegedly engaged in a sexual act with another man in the privacy of his own bedroom. A neighbor, jealous that one of the two men involved was a former intimate relation of his own, called the police and concocted a false report of a gun violation taking place at the home. The false report resulted in police breaking into the man's home, guns drawn, and arresting the two men involved. Not for any gun violation, as clearly none was taking place, but for violation of the state's anti-sodomy law, which was discovered only after the police had improperly broken into the home and improperly searched the premises. Even the act of sodomy itself came into question, as two officers claimed they saw the two men engaged in a sexual act. Two other officers said they saw nothing of the kind, while the two men themselves claimed to be in separate rooms and fully clothed at the time the police arrived. A 6-member majority of the Supreme Court found that not only were the men's due process rights violated, but that ultimately the state of Texas could not justify their anti-sodomy law, as there was no real compelling state interest in outlawing sexual activity between two consenting adults in the privacy of their own home. Justice Thomas, ignoring both the meat of the issue and its finer points, ruled that he could find no right to privacy or relevant liberty in the Constitution. Thomas chose to ignore not only the circumstances which led to the arrest, but also the core of law that had long established that states need to show a compelling state interest for deeming any activity illegal and meriting punishment. It should be no wonder that so many conservatives hail Thomas as their favorite Supreme Court justice. This case illustrates how Justice Thomas and sometimes other conservatives will have an aversion to anything in law that they simply don't agree with. Perhaps more troubling than the central issue of this case itself were the due process violations. The fact that the police only entered the home on the basis of a false police report, for which the neighbor responsible was later prosecuted and convicted, leads one to believe that at the very least, whatever was found inside the home should have been thrown out. The courts have long wrangled with this whole due process procedure, even though the Constitution outlines pretty clearly the steps government must take before they can enter your home, make an arrest, and gather evidence against you. You would think a real conservative who is so very fearful of big government would take due process a lot more seriously. But apparently not when it involves eavesdropping on your phone or internet communications, or when the police are called under false pretenses and it involves gay sex. In Justice Thomas's world, there's nothing in the Constitution whatsoever that would stop, let's say, a member of law enforcement from contacting a colleague and have that colleague phone in whatever pretense would serve as a reason for the police then to break into your home so they could look around, maybe even plant some evidence against you. Have you ever been stopped on the highway for weaving even though you weren't weaving? Or for a license plate light that was out that really wasn't? Or for changing lanes without a signal even though you remember signaling? And how many drug arrests and forfeiture and sale of impounded vehicles do you suppose have resulted from these draconian forfeiture laws you see all over the country? These are procedures which, in concert with such terms as probable cause, conservatives on the Supreme Court have upheld as perfectly legal. We have watched in recent years how conservatives have continued to work at the state and federal level to restrict women's rights to abortion and contraception, how they've fought to allow ever greater access to guns, how they've worked to give ever greater influence to money and power while suppressing the voting rights of the poor and the powerless, how they've written laws like Stand Your Ground in more than 25 states, which are little more than licenses to kill whenever witnesses aren't around, and where they've launched all-out assaults on workers to deprive them of bargaining rights, for leverage to fight for fair wages and safe working conditions. In each of these cases, it's not the Constitution that's been pursued, but a political agenda. Conservatism is a joke. Its basis in law is a joke. But far too many people are either ignorant of the law or apathetic to just what a mockery it all is. That is why we have ever more conservative legislatures passing ever more absurd laws and conservative courts upholding them. And these are the stakes as the Affordable Care Act comes before the Supreme Court. And also at stake are the legacy of the John Roberts Court and its already questionable integrity.